Welcome back, everyone, to another episode of the SERMAPod. This is the Sports and Entertainment Risk Management Alliance podcast. I'm the founder and CEO, Rich Lenkov. I'm also the host of the podcast, and we are very privileged to have James Nussbaum on to discuss a breaking topic. We like to deliver the most breaking news here on the SERMAPod, and this week, the House versus NCAA landmark settlement was reached, and we'll discuss that today. James is an attorney, professor, and expert in sports law. He is a partner at Church, Hiddle, and Antrim, which is CCHA Law, where he chairs the higher education and sports law practices. His practice group includes Title IX, NCAA compliance, NIL, institutional investigations, and athletics government. James, welcome. I know you've been discussing this settlement this week, so we're privileged to have you.
Yeah, appreciate it, Rich. We're excited to be on today. It's great breaking news, like you said.
So we've covered the story, but now that the settlement is done, we want to get your perspective on a bunch of different aspects of it. First, let's start with kind of the basics. What did the NCAA agree to in the House settlement, and why is this such a groundbreaking move?
Yeah, there's three major provisions, but I think the easiest way to understand it is from its inception, really, the NCAA has been focused on amateurism. It's taken different terms, but overall, uh, not having professional athletes participate in college athletics has been a big part of the NCAA's enforcement. And so uh, part of the House settlement is an attack on that model and alleging that all the schools and the NCAA colluding together to prohibit student athletes from being paid to participate in athletics was an antitrust violation. So the settlement agreed to three main components. The first one is back damages, student athletes that lost NIL opportunities, that weren't compensated for their participation in athletics or weren't compensated for the broadcast they were on, can receive just under $3 billion in damages total. The other two main provisions of the settlement are forward looking. One is related to paying student athletes, whether it's through institutions directly or how the NCAA or the new College Sports Commission, I'm sure we'll talk about, regulates third party payments to student athletes. And the third category is roster limits. The NCAA forever has had scholarship limits that dictate how many scholarships you can provide based off of specific sport, and they've replaced those with roster limits. So schools can give as much or as little scholarship money that they want as long as it's under those roster limits.
James, what was the legal theory or theories that gave the plaintiffs the upper hand here, and how did this differ from prior lawsuits involving the NCAA, like the Ed O'Bannon case and Alston?
At its core, it's an antitrust case. It's saying the plaintiffs were saying that the schools and the defendant conferences that they are members of and the NCAA colluded improperly to restrict the market on student athlete compensation, and they did that through their NIL rules. They did that through their pay for play rules or prohibition on what's called pay for play. You can't be paid to play an sport collegiately within an NCAA school. And so there are three different cases that were all consolidated as one. To your second question, I think that a lot has changed. I mean, the O'Bannon case was really focused on the name, image, and likeness issues related to participation in athletics, but that case was sort of the first one that started to chip away at some of these bigger questions about whether or not these student athletes can be paid. Subsequently, there was the Alston decision related to how much student athletes could receive in educational benefits, payments related to their education, and really the Supreme Court decision coming down as definitively as it did. There was a unanimous decision saying that the NCAA couldn't prohibit payments related to the education. I think that there was even a concurring opinion that's gotten a lot of attention from Justice Kavanaugh saying that he thought maybe there were even bigger problems. I think those cases kind of paved the way for this trio of cases. It was ultimately consolidated and led to the settlement that we have. It's just become over the last 10 years, just a very different landscape, I think, even for how the public views student athletes and whether or not they should be compensated.
Yeah, definitely been an evolution on that for sure. James, do you think that this settlement is the end of the story for antitrust allegations? Does this foreclose further litigation, or is this just perhaps the tip of the iceberg, especially considering how NIL is still evolving?
I don't think it's the end. I think there are some pieces of the settlement. I talked earlier about the three things that the NCAA gave up in the settlement. I think the thing that the NCAA and the defendant conferences were hoping to get in the settlement was some type of reprieve from the litigation. And so they built in some mechanisms into the forward-looking pieces of the settlement that try to prohibit or at least lessen the risk of continued litigation. Student athletes will have to sign a release before entering to participate in athletics. They can opt out of that, but that's a little bit of friction that'll make it less likely for claims to continue. And then also, if there's any dispute about how the NIL agreements are governed, that goes to third party arbitration. So any litigation after the arbitration would be a high bar to overturn a third party arbitrator decision. They're trying to build in some protections there, but at the end of the day, reading the approval opinion from Judge Wilkin, I think 9 or 10 different times she says some version of that's an antitrust matter that's not in front of me and I'm not deciding on it. Sort of being really clear what she was deciding on and not deciding on, and I think even foreshadowing, hey, there could be additional litigation coming, and that's just antitrust litigation. I think it also opens up questions about Title IX that people are trying to figure out. I know there are attorneys very excited to file Title IX cases once these payments start being made.
James, anyone who is paying attention, anyone who follows college athletics knows that there's been a dramatic shift over the last few years to the Power Five. Certainly, there's been realignment over the last couple of years. You've got, West Coast schools in,
Right.
the Big East and the Big Ten and so forth. The $600 million portion of this is being paid by the Power Five. Does this further signal a permanent break from a more centralized system for the NCAA?
I think it's a matter of time. It seems like more and more those schools are the TV deals that they're commanding, the amount of revenues that they have, and they're able to offer that under this settlement agreement is just going to make the chasm that's already there between the schools that have a lot of resources and the schools that don't wider and wider. They're going to continue to want more and more autonomy in the rules. We're already seeing that in some of the negotiations over the college football playoff and which conferences get guaranteed bids and which conferences get at large bids and how that works. And I think those, because they have the money and they're able to control some of those discussions, that's just going to continue in a way that I don't know how it's feasible to continue sort of the big tent model that the NCAA has tried to hold together for so long.
James, we're speaking of revenue sharing. We see revenue sharing in lots of professional sports. I mean, flat out, is this just the full out professionalization of college athletics? I mean, in many ways, this settlement and this is a way bigger business than a lot of professional sports leagues, and only continues to grow.
I think so. I mean, the Johnson case is still pending on whether or not student athletes are employees of their institutions, but I think that is going to happen at some point. There's already a lot of momentum behind designating student athletes as employees, whether it's through litigation or whether it's through the NLRB or some of these other agency mechanisms. I think it's very likely that we end there and with some sort of collective bargaining, whatever that looks like. And the House settlement, to your point, is just the next step in that professionalization.
What kind of challenges do you foresee in actually administering the revenue sharing model, given that there are hundreds of schools, lots of different models, infrastructure, different resources? How will that work?
Yeah, from a school to school standpoint, we're encouraging clients to take just a really hard look at what their mission and beliefs are, what their philosophies are, what are they trying to accomplish, because there are so few schools that are going to be able to max out the cap under the house settlement agreement. So trying to use this new opportunity to give benefits to student athletes in a way that aligns with your mission and accomplishes your strategic objectives is easier said than done. A lot of these schools are sort of having a little bit of a keeping up with the Joneses type mentality, and they want to do what the Power Four schools are doing, but it might not always be the financially prudent thing to do. Then again, Title IX, like we mentioned earlier, it wasn't contemplated when Title IX was first written that student athletes would be paid hundreds of thousands or millions of dollars for name, image, and likeness rights. And so figuring out how Title IX applies to these payments, how they're managing that risk, what the return on some of these payments is for an athletics department makes for a really complicated problem for athletic directors and general counsels and presidents and boards that are trying to manage this.
So, do you see Title IX challenges, assuming that male dominated sports will receive a larger share of these payouts?
Yeah, no doubt. I think there will be Title IX lawsuits. I think it's unclear how those will be determined, but there's just too much money at stake. There's already a couple of cases pending, one against San Diego State University, one against Oregon, that aren't directly related to the House settlement because they were filed before the settlement was approved this week, but they're related in a way that's going to give us a lot of indication for how successful those Title IX claims are going to be. But I would be absolutely shocked if there isn't litigation in that area.
James Nussbaum, thank you so much. Follow James on social media. His website is cchalaw.com. He's active all across the blogosphere, Sports Law Blog, California Sports Lawyer Podcast, which is an excellent podcast. I think still run by a friend of the show, Jeremy Evans, if I'm
It is. That's right. Yeah.
prior guest, good friend. And please come back and update us as this important issue develops.
We'll do. I appreciate it. Thanks a lot, Rich.